Thank you.
Excellent. We are on the record in 18cv27149, Byers versus Estate of Nichols, and Patrick Dyke and Heather Dyke, both of whom are present in the courtroom. I have Ms. McLeod and Ms. Ostrom on the phone on behalf of plaintiff, and we have a variety of motions to deal with this morning. I'm just going to try and take them at least roughly in the order in which they were filed. And there we go. And the first one is defendant's motion to dismiss claim number 1 that was filed February 5th. Mr. and Ms. Dyke, I did review the motion. Do you have any additional argument you'd like to make on that motion?
Your Honor, we attempted to get an inventory of what would be dealt with today, and we did not receive that, so we need a second to orient ourselves if we can.
The order that was entered on February 14th did indicate we'd deal with any pending motion.
Motion to dismiss claim 1, yes.
Yes. Any additional argument on that motion?
I don't know if I've objected to her response, but in general, I typically object to any response she makes. Just for the record.
What's the basis of the objection?
I'm not sure if I responded formally to her.
I don't believe that you did.
Okay, I have this note. I don't think I did. I think our position is explained there.
So you don't have any additional argument?
Yeah. This is one we filed on the 5th.
Correct.
I just thought that a motion to dismiss, I believe this was a motion
Entirely. I feel like the default result, if the state results in the state, we signed a quit claim deed that Mrs. McLeod suggested, and we don't really understand why we need to be involved further.
Okay. Ms. McLeod, Ms. Ostrom, who's taking that motion for you?
This is Ms. McLeod. I can take the motion.
Go ahead. Any additional response? I did review the opposition that you did file.
Then there's nothing additional. We were not able, part of that quitclaim deed was some part of our settlement discussions, which would not be appropriately before the court anyhow, and it just factually didn't work out that way. And so it's our position that they have not asserted anything in the motion itself that substantively or procedurally would lead to dismissal of that claim.
And so here's where I'm at on that motion. Typically, a motion to dismiss is dealt with prior to filing an answer, or it's waived. There's some exceptions to that. It's unclear if this one would fall within those exceptions, at least arguably unclear whether it would fall within those exceptions, but the reality is that what you are seeking is a dismissal based on facts that are outside the pleadings themselves, which is really not an appropriate motion to dismiss. Motion to dismiss is, say, primarily a procedural and not a factual motion, although occasionally facts do play into that. It's also apparent that the quitclaim deed doesn't resolve all of the potential issues on Claim 1. So I'm going to deny that motion. Let me just make a note to that effect, which then should move us to... Yes, Mr. Beck.
Aren't the other issues with the estate resolved with the default against the estate?
The issues with regard to the estate, I'm trying to make sure I'm accurate here, which is why I'm pausing for a moment, are essentially resolved with the default. There are some issues about calculating damages on claims 2 and 3. It also appears that, based on what Ms. McLeod has raised in her motion, that ultimately we are going to need a judgment one way or the other on Claim 1. Now, the issues with regard to the estate probably resolved on that judgment once we get there, but we're not there yet.
Does this mean our quick claim deed is irrelevant?
May or may not. It probably depends on what point in time we're looking at, which is it's a more complicated question than just that. So let's see, your next motion was the motion to allow use of interrogatory discovery, which was filed February 7th. And I don't have it in my notes, but Ms. McLeod, I believe that's one of the ones you addressed just by letter.
That one we actually did file a formal opposition on the grounds that it was premature to ask for some sort of an extreme type of discovery and further that
oh, that's right.
Objection. Simply not allowed.
There it is. It filed it on February 25th. I apologize. So, Mr. Dyke, did you have any additional argument on that motion?
I believe she said extreme. I believe interrogatory discovery is allowed in almost every other state in our nation.
It's not allowed in Oregon.
I know, but it is allowed. So how can it be viewed as extreme when Oregon might be the only state that doesn't allow it?
And I don't know that determining whether it's extreme or not is the issue. Do you have any additional argument you'd like to make on that motion?
So this means that we can only ask those, we can ask interrogatory questions at a deposition.
You can conduct a deposition, yes.
So this leaves us with the burden of having to conduct, I don't know how many depositions to get answers to the interrogatory questions.
So do you have any additional argument on this motion? Ms. McLeod, any additional argument on this motion?
No, Your Honor.
It's pretty straightforward and simple to me, Mr. Dyke. Oregon has made the decision for a variety of reasons, some good, some bad, and folks will line up on opposite sides of that argument, I'll guarantee you. But Oregon doesn't permit interrogatories, and one alternative method to get that information would certainly be a deposition, but that's a decision that's been made by the legislature. Authorizing interrogatories would be extremely unusual, particularly given the facts of this case at this point. So I'm going to deny that motion as well, which then moves us to your motion to join Carrie Byers, and looks like that one was filed on February 7th. Find it. There it is. And I believe a response was filed to that on the 22nd. So did you have any additional argument on that motion, Mr. Mistake?
Her defense have demonstrated no reason why Mrs. Byers is a necessary party. I will explain that she could argue for ownership of this by adverse possession just as easily as Mr. Byers could. So it seems to make her a significant party in the matter. They were co-tenants, co-owners up until 2013. And inquired with the plaintiff's attorney about the 10-year period they were going to be using for their adverse possession claim. She would not answer that. So I don't know what period of time they were seeking to use for that Maybe because it was an interrogatory question, she wouldn't answer it.
Ms. McLeod, anything on this motion?
Just very briefly, as I would say that, if it ends up that she is a fact witness, that certainly is appropriate, but she's not on title now. She's not a necessary party to this proceeding, and we would object to having her be added to the claim. She holds no interest in the property.
What's the basis of your objection?
They were co-owners for the first 13 years of possession. And the conveyance, bargain of sale deed she granted to Mr. Byers is defective.
How's it defective?
It includes property that they didn't have ownership of.
Which is the disputed property that we're talking
sir.
about
Yes,
now.
Sir. I included, I think that.
Which I think in and of itself establishes that she's not a necessary party to the case, because any interest she had in the disputed property, she's given to Mr. Byers by that deed.
I would agree if it was a quit claim deed, but it's a bargain of sale. It's a sales.
Which actually grants a better interest than a quit claim typically does. So I can't find that she's a necessary party based on what we've got here. So it's appropriate to deny that motion, and it doesn't look to me like she's got an interest based on at least what the parties have provided so far. So that's going to move us to the motion for the additional, to request additional admissions. When was that one filed? That one was also filed on perhaps it was filed on the 8th, yes. Mr. Dyke, any additional argument on that one?
Given the number of parties involved, we really need, given the number of parties involved and the disallowance of interrogatory discovery, we need everything we can to ferret out all the truth involving all these parties. We would like to arrive at the truth regarding all these parties.
And I guess I'm a little, I don't know that I'm so much confused as concerned when you say there's so many parties. Who all are you referring to? Because there's only one plaintiff.
Well, there's the plaintiff's personal attorney and the bad faith conduct that occurred there. There is WASCO title. There is Stewart title. There's a law firm of Ms. McLeod.
But most of those folks would not be subject to a request for admission.
They're involved in this whole dispute.
That may or may be true, but they're not subject to a request for admission.
Can you tell me
as a non-party?
The main nature of third-party requests for admission? Do I have allowance for that, separate from?
The third party is not in a position to respond to a request for admission.
I could depose it.
That you could do. Assuming you follow the appropriate procedure, you certainly can depose a party that may be a witness. I should probably clarify that. There may be reasons that you can't depose some of those folks that you identified, but we can cross that bridge if we get there. Typically, a fact witness who could testify at trial, you can depose. Ms. McLeod, anything with regard to the request for the additional admissions?
No, the only thing I would add is that even if it was proper to make that request, it's our position also that it's premature. We have the first set of outstanding requests for admissions aren't even due for another week still, and so it seems to us premature to be asking for extra discovery when we haven't even released the first.
She already protested my original request for admission.
And you withdrew them. So we have one set of requests for admissions that are currently pending.
Okay. So with regard to the request for additional requests for admissions, I don't see that one that good cause has been shown, which is required at this point in order for me to order additional requests. Additionally, the proposed additional requests need to be filed with the court before I could grant the right to make additional requests, and they haven't been.